Hello everyone, myself Prashant. Hope you all are doing great. So our today's topic is right to constitutional remedies, and it is under Article 32 of India's Constitution, and obviously it is a fundamental right, FR for fundamental right. This is our YouTube handle at the rate only UPSC and PCSGS. Subscribe to our YouTube channel if you like the videos. So, a right to constitutional remedies. So, on this article, Bhim Rao Ambedkar famously commented that this article is very soul of the constitution and very heart of it. So, this statement in itself highlights the importance of this article 32. This article 32 is also a basic structure of the constitution. Now, what does basic structure of constitution means? So it means that parliament cannot remove this article 32 from the constitution, and it also means that if amendment is being made to right to constitutional remedies, then amendment cannot be done in such a way that the very purpose of article 32 is lost. So, Constitution has four provisions for this Article 32. We will know those four provisions one by one. So, first provision states that right to move Supreme Court by appropriate proceedings for enforcement of fundamental rights. Needless to explain. Then the second provision states that Supreme Court have power to issue direction, order, writs for enforcement of any fundamental right. So we know there are different writs like habeas corpus, quo warranto, certiorari, then and other writs. So Supreme Court has power to issue all types of writs or all types of order for enforcement of any fundamental right. Any fundamental right means for all the fundamental right. Supreme Court has power to issue these orders. Then the third provision states that Parliament can empower any other court other than Supreme Court and High Court to issue direction, orders, writs of all kinds. So Parliament here has the power to empower other courts as well for issuing direction and orders or writs of all kinds. So other courts can also issue all types of writs, provided provided the fact that that particular court is empowered by the Parliament. So the fourth provision states that right to move Supreme Court shall not be suspended except as otherwise provided by Constitution. So in accordance to the Constitution only right to move Supreme Court can be suspended. However, President can suspend a right to move any court for enforcement of fundamental rights during national emergency. It's very important. So here President has the uh, power to uh, suspend right to move any court, whether be it Supreme Court, whether be it High Court, or whether be it any other court which is empowered by the Parliament. So President can suspend the right to move any court and for enforcement of any fundamental rights, right? And when will it happen? So it will happen during national emergency, any for national emergency. Here it is also important to note that only fundamental rights can be enforced through Article 32, right? So, and this is for this is uh, this is for fundamental rights, you should know. Now we'll see writs. There are different types of writs and their scope. We'll discuss that. Then here you should, but before that you should know there are the writs of Supreme Court differs from writs of High Court. In what ways? We'll know. So the first manner in which writ of Supreme Court differs from writ of High Court is that Supreme Court can issue writs only for fundamental rights, while High Court can issue writs for fundamental rights as well as legal rights. So Supreme Court has the power to issue writs only for fundamental right. Very important. While High Court can issue writs for fundamental rights as well as a legal right. So High Court can issue writs for right to property also. Why? Because right to property now is a legal right under Part 12 of the Constitution, Article 300A, right? Under Article 300A, right to property is a legal right. So for right to property, High Court can issue a writ, but Supreme Court cannot issue writ for the enforcement of legal right. Very important. Then the second manner in which writ of Supreme Court differs from writ of High Court is that Supreme Court can issue writs for person from any part of the country, right? While High Court can issue writs only for person within the state or cause is from within the boundary of state. So it's clear Supreme Court, since Supreme Court is at central or at federal level, so Supreme Court can issue writ for for person from any part of the country, while High Court has a boundary, right? It can issue within the state or if the cause is from the boundary of the state, if the cause is from within the boundary of the state. Now the third manner in which a writ of Supreme Court differs from writ of High Court is that Supreme Court cannot refuse to exercise its writ jurisdiction, while High Court can refuse to exercise such power. Very, very important. So Supreme Court cannot refuse to exercise writ jurisdiction. Why? Because we know that Supreme Court is the guarantor of fundamental right. Supreme Court is the guardian of Constitution. So Supreme Court cannot refuse to exercise writ jurisdiction. It has to exercise. However, High Court can refuse to exercise writ jurisdiction. So if High Court refuses to exercise writ jurisdiction, then in that case, person can move directly to Supreme Court for the enforcement of their fundamental rights. So this is it, I guess, regarding right to constitutional remedies. In next video, we'll see different types of writs, their scope, and all those things, right? So for now, thank you for your time. Thank you so much.